now. Okay. This is a very timely webinar as it is happening right before the National Healthcare Decisions Day 2.0, which is on July 16th, the day after the new tax day of July 15th. So we are happy to be hosting this webinar and to be partnering with 4 other entities. The host is the North Carolina Serious Illness Coalition. And if you aren't aware of who we are an outgrowth of work that was done last year by the North Carolina Institute of Medicine's Task Force on Serious Illness. And right now there are about 120 participants in the coalition from about 70 healthcare organizations, universities, businesses, advocacy groups across the state who are concerned about issues facing those who are living with and caring for people with serious illness. It's a very proactive group. I've never been involved with a group that's as engaged as this one is in doing the work that was recommended from the task force. So it's very exciting to be a part of that, and also to have our partners today who are a part of the coalition. And I'm going to introduce those folks to you. Shannon, can you advance that screen and we'll get the names of those partners there. The Association for Home and Hospice Care, of North Carolina, and being represented by Shannon Pointer, who's the vice president for that organization. The Carolina Center for Hospice and End-of-Life Care, and being represented by Marset Hassan, who is the president and CEO. Health Sciences Innovations Group, and I am representing that entity, and we're a 501c3 that houses the Mind My Health Advanced Directive platform. Pointer Sproul is a law firm being represented by Ken Burgess, who is actually going to make our presentation today. So I'll introduce you to him a little bit more in a moment. I just have a few housekeeping rules, and that is I'm going to mute everyone who's not muted by the time we start the presentation, just to cut down on background noise that might occur. We are recording this webinar, and I will send out a link to all those who registered at the end of, as soon as we get it back, the recording back. And I wanted to introduce you to the format today. We're going to give Ken Burgess about 30 minutes of our hour for his presentation, reviewing the advanced care directives that we use here in North Carolina, the differences in them, and then he will talk about the amendments that have been made for their legal requirements to these advanced directives. And then we're going to have a period for Q&A. Please hold your questions till the end. You can jot them down yourselves in case you're scared you'll forget them, or you can enter them into the chat room, and Marset Hassan is going to monitor the chat room, and she'll be sure to ask your questions at the end of our presentation, or you can raise your hand and ask a question yourself. There's a, you can just raise your hand on the screen if you're videoing, if you're on the video, or you can use the little icon in the chat room to raise your hand, or in the, not the chat room, but down in the reactions section. Okay. Without further ado, let's move on to why you're here. Ken Burgess is a healthcare attorney with over 30 years of experience advising clients on a wide range of regulatory, litigation, compliance, and operations issues. His practice focuses heavily on issues affecting long-term care and acute care providers. He advises providers on legal issues arising in their realm of operation, and he also represents ancillary providers such as pharmacies, DMEs, and others. He advises, on certificate of need, Medicare, Medicaid enrollment, and licensure issues So he has the experience and the legal mind and the interest in this, and he brings his passion and his knowledge to us today, and we so appreciate that, Ken. And sorry that you weren't able to be with us by video, but between your audio and Shannon's controlling the slide deck, I think we're going to have a great time today. So take it away, Ken.
All right, thank you, Marcia, and welcome everybody. I want to thank the group co-hosting this. As you can probably tell, we've had a few techno issues this morning, so I can see you, but you cannot see me. And I'm also hearing echo, so I'm going to pick up the receiver. I'm going to rely on Marcia and others if we start having serious technological problems, then we'll go from there. Shannon, if you would go to the next slide, please. All right, real quickly, our goal today is to do a very quick high-level view of both the importance of advanced care planning and a quick dash through the typical North Carolina advanced directives and medical orders, and then spend most of our time talking about these recent legislative amendments that Marcia alluded to. Next slide. All right, real quickly, I'm going to highlight a few of these slides, leave them for your reference. I know you'll be given access to them, but I like to remind people that all the talking we do in states about advanced directives started back in the early 90s when I still had brown hair with the Federal Patient Self-Determination Act, which required most Medicare certified providers to have processes and procedures designed to implement and empower patients to make their own end-of-life choices. Those led to state laws like the ones we have here in North Carolina that created statutory processes and forms around living wills, healthcare powers of attorney, and some related healthcare decision documents like the MOST form and the portable DNR orders that travel with patients from care site to care site. Next slide. So I want to make a quick distinction. I see some doctors on the screen. John Blizzard has his, it looks like his scrubs on this morning. So you'll know this, but everyday run-of-the-mill folks often confuse an advanced directive with a medical order. So I want to just state the obvious. The advanced directive is a patient saying, when I can no longer tell you, either my agent or a doctor, what I want, then here are my choices. And we do those through the healthcare power of attorney and the living will. Medical order is required to implement any advanced directive. It may be an old-fashioned order like we've done for 100 years. It could be a formal pre-printed DNR order. It could be a MOST form. But without the doctor order, the advanced directive is nothing more than a statement of wishes. Next slide. I want to do a quick spin through the living will. After many years of teaching this, I am always amazed how many people still confuse living wills and healthcare powers of attorney. So I'm going to give you the not any smarter than Ken version of how to always keep this stuff straight. The key difference, of course, living will is me, the patient, speaking directly to a healthcare provider. The healthcare POA is me telling a third party what I want for them to tell the doctors when I can no longer speak for myself. Living will limited to life-prolonging measures, so it's much more narrow in scope than a healthcare POA. Next slide. But living will can cover any kind of life-prolonging measures, which North Carolina defines as any procedure or intervention that, in the view of the attending physician, serves only to artificially postpone the moment of death by sustaining, restoring, or supplanting a vital life function. So on the one hand, it's limited to end of life. On the other hand, it can be quite broad. People are often surprised to learn that something as benign as penicillin can be a life-sustaining measure given a patient's medical condition. Next slide. Again, these documents can authorize the withholding of nutrition and hydration, but also other measures, like I mentioned, CPR, penicillin, whatever the doctors say is keeping me alive artificially. But as you know, they never authorize the withholding of comfort measures. They only kick in, i.e. become effective, when the doctor certifies that I'm incompetent, meaning I can't make or communicate any longer my own healthcare choices, and I meet one of several trigger medical conditions. Next slide. Those are that I'm incurable or irreversible, and that without intervention, I'm going to pass away pretty quickly. I'm in permanent state of unconscious. We used to call this the old persistent vegetative state. Or I have clinically diagnosed advanced dementia that is not reversible. Next slide. All right. So again, living will, limited life prolonging measures. We have, as you know, in this state, a statutorily approved form. If you use it, it's always valid. But any kind of form will do, and we're going to talk about some in a second, as long as it clearly states the patient's wishes and meets all of the formal execution requirements we're going to talk about. Next slide. All right, here is the reason we're here. What are those minimum procedural requirements embodied in the law? The document has to be signed by the maker, the patient, in the presence of 2 qualified witnesses, signed by the patient while physically present with a notary, and then notarized. And in North Carolina, a second physician confirms that, yes, Ken is in one of those 3 trigger conditions, and therefore his living will can become effective. Next slide. Okay. I'm going to leave this here for you. This is a slide about one of the more controversial parts of living wills, which has to do with artificial nutrition, hydration. You all know that I can tell a doctor, you may withhold things like nutrition, hydration, or you must withhold them. I can give that doctor the decision. And in the forms, I can basically be very clear about what I do and don't want when it comes to any kind of life-prolonging measures, including artificial nutrition and hydration. Next slide. All right. So this is just a summary of everything I've just said. Life prolonging care is withheld if I've got a living will properly completed with all the procedural requirements. I'm in one of the conditions I've already described, and my doctor and a second doctor confirms I'm in that condition. At that point, my living will can take effect when a doctor issues the corresponding order. All right, next slide. All right, contrast that to healthcare POA, which I mentioned earlier, is now me as the patient telling a third party I trust, hopefully, what I want them to tell my providers once I can no longer do that myself. In North Carolina, the forms that are out there, that we'll talk about momentarily, as long as I'm expressing clearly what I want that healthcare agent to know, it can be in any form. These things are what we lawyers call durable by nature, meaning they survive my loss of mental competence. If you think about it, it makes sense because these things only become effective, like living wills, once I can no longer make or communicate my own healthcare choices, whether that's temporary or whether that's permanent. So they're durable by nature. They survive my lack of capacity. Next slide. All right. And again, in North Carolina, we have a statutory form that lets you check off the box, meaning I'm telling my agent, Marcia Van Hecky, who just got named, here are the things I want you to do or things I will not allow you to do. And I can be very specific, or I can write in additional powers or limits to my healthcare agent. Next slide. Again, we've got a statutory form. A lot of us lawyers in the early days, AKA 2007, when we last changed these laws, we're really pushing everybody, please use the forms in the statute because they are always going to be legal. The older and wiser I have become, and the more I hang out with people like Mariset and Marcia and Shannon, I have now dubbed myself a true believer advocate and less of a lawyer. So we now like to promote the alternative forms. mainly the document we call a practical form for North Carolinians, because it combines the living will and the healthcare POA into one simple, like 5-page form. If you ever tried to explain to a family member the statutory forms versus these, you will quickly become a believer in the practical form. Regardless of what form we use, the minimum requirements in North Carolina remain clear expression of who is my agent, what they may and may not do for me, my signature, and you'll see on the slide in bold, signed in front of 2 witnesses and signed before a notary. The reason we bolded that here and in the living will slide is that's the stuff the General Assembly has helped us with during the COVID crisis, we're going to get to in just a second. And the reason we're going through all this quick review is so everybody has a basic understanding of the documents, the types of forms, these minimum legal requirements, and how those have changed. Next slide. All right. I always include this slide for my doctor and nurse and therapy clients. In North Carolina, if you follow the laws, as I've just quickly described them, there are protections from liability for us, you providers, from criminal liability, i.e. wrongful death, homicide or manslaughter, civil liability, wrongful death, and against you losing your professional license for some alleged malfeasance. Next slide. All right, now we're 20 minutes into this. I'll blame 5 on Marcia and 15 on me. And we're now at the point we really came to talk about. The North Carolina statutory amendments, and I call these the COVID amendments because they were part of legislation enacted in early May that literally was entitled the COVID-19 Recovery Act, AKA Senate Bill 704. It did 3 things that warmed the hearts of those of us who promote end-of-life planning. It temporarily waived the requirement that normally applies of 2 witnesses to complete a healthcare POA and a living will, permits video witnessing of those 2 documents. We're going to talk about that in a moment, and permits video notarization of living wills and healthcare powers of attorney. Next slide. All right, this is the text from the actual bill as it relates to the waiver of the normal 2 witness requirement for a healthcare POA. I'm going to summarize it for you because we really want to get to your questions. But here is the text. The highlights are this, that as of May the 4th and until now, August the 1st of 2020, via a recent extension of this date, during that May 4th to August 1, 2020 for now, and as long as the governor's COVID state of emergency remains in effect, the requirement of having 2 witnesses to make these 2 types of documents legal have been waived. So those of you who work in home care, hospice, institutional settings, and hospitals, it is impossible with all the restrictions to get witnesses into a home or a facility. And so this has been a huge impediment to end-of-life planning at a time when it is never more important. Big deal. One thing I've got in bold here, if you are using this temporary statutory flexibility during the time window I've mentioned, the healthcare POA that you help create or you create has to contain a short, plain statement indicating this was executed in accordance with the procedures of Senate Bill 704. I'm going to give you some examples of language like that in just a minute so you don't have to get creative. Real quickly, many of you may have been aware of this provision and thought it ended August 1st because it does right now. Let me go to the next slide, Shannon, please. Yeah, okay. Well, I'm getting ahead of myself. Well, the news flash we have for you from last evening is that after a lot of lobbying by lots of people on this joint committee, the House yesterday passed an extension of this to March 1 of 2021. It is now winding its way through the Senate, and I'm told it has excellent chances of passing. So our hope and dream is that in a very few short days, this waiver of the 2-witness requirement for these healthcare POAs will be extended on through March of next year. And please rest assured, without spilling too many beans, that every single person who is sponsoring this group, this webinar today, is working actively to make these things permanent, if we can. A lot of work to do, but we are. So, all right. So healthcare POA, 2-witness requirement is waived for now till August, hopefully soon until March next year. Next slide. All right, the same change was made for living wills. So the normal requirement of having 2 witnesses to make a living will valid has been waived, same window of time, starting May the 4th, as long as the COVID declaration of emergency remains in place, and for now until August the 1st, but we're hoping it will soon be extended to March 1, 2021. And relatedly, a living will created under this flexibility also has to state it was created pursuant to this law. And we'll explain that more to you in just a minute. For both of these types of documents, a living will and a healthcare POA that are executed under this flexible procedure without witnesses, once the end date happens, whether it's going to be August of this year or March of next year, these documents remain valid. You do not have to recreate them. And that's the reason we require this big bold statement, this living will or this healthcare POA was created under Senate Bill 704, so that a year from now, when hopefully life is more normal, someone picks up a document created in this window, they don't see they don't see the witnesses, and they're like, oh, what's going on? Well, here's a big marker saying you don't see them because they weren't required when I created this thing, and it is still valid. So I just wanted to stress that. That's why that big bold language is critically important. Next slide, Shannon. All right, let me say a word about the practical form. It's actually called an advanced directive, a practical form for North Carolinians. I hope you've all heard about it. If you haven't, reach out to one of us. This is a form that we widely promote, and I am told from pretty reliable sources that every major hospital system in the state now accepts this form, which is beautiful. It combines the living will and the healthcare POA into one form. That's great. The other good reason to use it during COVID is all these flexibilities that we are talking about, 2 witnesses and a couple more I'm going to get to in a second. If you're using those, you only have to use them once, right? Because you're creating one document that has living will and healthcare POA in it. You're not having to execute 2 separate documents. So literally with the practical form, you can execute the document between now and August the 1st without witnesses, and maybe soon until March the 1st without witnesses, using only a notary. And in a second, I'm going to tell you about an emergency video notarization process which makes this work. So stay tuned for more on this, but another reason to use that form. Next slide. All right, what if I still need a witness, though? I either need a witness or I need a notary, but I can't locate one and I have no access to one. Well, this new Senate Bill 704 contains more flexibilities, which are video witnessing and video notarization. Now, let me say before I get into details, if you're relying on the waiver of the 2-witness requirement for an advanced directive, you never have to worry about doing witnessing through video. But we cover it today because if that section is not extended past August, which is a month away, or if life continues as it is today past March and this flexibility is gone, you may then need to know about it, and so we want to cover it very briefly. The part of Senate Bill 704 that talks to these 2 procedures is quite long and detailed. I'm going to give you the highlights in Kenny B's English, as my friends like to call it. Next slide. All right. So, Section 4.1C of Senate Bill 704 authorizes video conference technology to perform an emergency video notarization. Now, this applies to any kind of document that needs to be notarized, not just living wills and healthcare POAs, but it applies to us too. Here are the highlights. The notary public and the document signer, the patient, have to be able to see and hear each other in real time. You must be able to record this process, and you can do that through any video recording device, your iPhone, screenshots of your face, but what you need to be able to record is the face, the ID, if required, and the document being notarized. You have to have clear, real-time, simultaneous audio facial recognition. You can't have any of this process be pre-recorded. If the notary is going to ask you for ID, the patient, meaning they don't know you, normal routine ID procedures apply. State-issued ID with your, hair and eye color, date of birth, expiration, nothing's changed there. Both the notary and the maker of the document have to be in North Carolina at the time. It's a state law. And the principal has to be able to verify that I am in the state and I'm in County X, and the notary is going to indicate in the stuff they do where the principal is located. Next slide. Okay. The notary has to physically see the document maker sign the document. Okay, great, I got that. Now what? I'm in one room across town, the notary's in another. How does this actually work? Well, we've done all this real-time video sharing. Now the maker or their agent will sign the document, then fax and scan it to the notary, whatever medium you like, who will notarize it and return it to the patient or the maker. Now this works for what we call non-wet signature documents, meaning I don't need original ink and a raised seal, which these days is the vast majority of what notaries do. If you're in a situation where you need a raised seal, wet document, you can see in the bill how you do it. We don't need those for living wills and healthcare POAs, so I'm not going to cover them. Now, this part of the law, the emergency notary, expires March 1, 2021. It was extended from the original August date a few weeks ago. So again, any document notarized through this process between May the 4th and midnight on March the 1st does not ever need to be re-notarized. The notary is going to have on it a statement. I notarized this document consistent with either Senate Bill 704 or flexibilities during the COVID crisis. So that's why a document has to be marked that way, so we know a year from now it was properly created. Next slide. All right. We're at about 10:30, and I see a lot of questions, so I'm going to summarize this real quickly. This emergency video notarization is what I just talked about. We have the exact same flexibility for witnessing. So theoretically, a patient can be sitting in their home or a hospital or wherever. A notary can be in a different room, and I can have two witnesses in two more rooms. We're all hooked up through technology, and I can sign the document, have it witnessed, have it notarized, and exchange it. So let's run through how that works. Again, I have to have real-time video technology. And what the law says is if we use this process we're about to talk about, then the documents are deemed to be signed, quote, in the presence of two witnesses, which is what our law requires. Except it doesn't require it during COVID for the reasons we talked about earlier. We have that temporary waiver of the witness requirement. But if you're needing it, then you have to have video real-time that allows audio and video interaction between the document signer and the witnesses. The witness has to see the principal sign the document, and then the witness signs a copy of the document, and then we get them together by using what lawyers call counterparts, meaning Marcia signs a copy in her office, I sign a copy in my office, we swap them and put them together, and that creates one perfectly legal document. Next slide. Okay. Again, the attestation has to state or the document that both people were physically in North Carolina, the county where each witness was located, and the county where the signer was. And there's your expiration date right now of March 1, 2021. Next slide. Okay, I mentioned earlier that we want any document that is executed via the no witness waiver, the emergency notary, or the emergency witness to have language that says this thing was created during the COVID crisis under Senate Bill 704 or whatever moniker. You don't actually have to recite the statutory language per Senate Bill 704. So here is a sample of some language that one system is putting on their documents. You can look at this on your own time, but it basically is a flag that this thing may look different than pre-COVID and post-COVID, because it is, but it's perfectly legal. Next slide. All right. Here is another example of language that a system is using in bold there. Please be aware, if you are borrowing language for the purpose of marking these documents as COVID emergency documents, read it carefully. Some people created language before the dates for these two flexibilities got waived. Just make sure that what you're putting in still now says it references the law or the COVID crisis and references the correct date, which is going to be March 1, 2021 for video notaries, video witnesses, August 1, 2020 if you're operating under the two witness waiver requirement, unless that gets extended, and we will then let you know. I mentioned earlier the practical form that we all love. Some hospitals have actually taken that and revised it, so it removes reference to witnesses and has proper dates in it, so you can maybe find that. And here on this slide 28 is a link to a document I got from my good friend Marcia about how to complete an advance directive during the pandemic, so I highly recommend that to your review. Next slide. All right, real quickly, we realize these flexibilities are not perfect. Not everybody has access to the internet or good access. Fax machines don't have scanners. So look, they're not perfect, but they're what we got, and they were not easy to get. A lot of us feel like the laws don't go far enough. I mentioned earlier we want some permanent changes along these lines. We are still only one of 4 states that requires both 2 witnesses and a notary public for living wills and healthcare powers of attorney, and that existed long before COVID. So we really want to use this opportunity to try to get some of these laws made permanent or at least longer lasting. Next slide. All right. Real quickly, on your slide here are links to the pre-COVID statutory healthcare power of attorney and healthcare living will forms. People always ask me for those. Please note, if you go to these links, these are the pre-COVID ones. So they're going to refer to 2 witnesses, notaries, and so forth. So just want you to have them. Next slide. Here's a link to the practical form that I mentioned earlier that combines both documents into one. Again, this is also a pre-COVID version. So if you're using it, what most folks have done is mark through and have the patient initial in the margin, the part that talks about 2 witnesses, and add that boilerplate warning or bold that we talked about saying this was executed under Senate Bill 704 or pursuant to the COVID flexibilities. And finally, there are updated versions of the Living Will and Healthcare POA statutory forms on the Secretary of State's website that do exactly that and have the right dates in it if you want to use those forms. But again, remember, those are indeed the longer forms. Next slide. All right, Marcia, I'm going to turn it back over to you to talk about quickly these links, and then we've got a slew of questions, it appears, down below.
Yeah, I'll do this. Thank you, Ken. I'll do this very quickly. There are 4 links here. The first one is to the step-by-step guide on video notarization that Ken referred to. The last three are samples of legally approved revised forms from 3 healthcare systems, Atrium Health, Novant, and Wake Forest Baptist. They have given us permission to share these with you. You can adapt your forms from one of these, take a combination of them. But again, remember, these do not include the new date of March 1, 2020 for video notarization. So you will have to change those. But you'll get a copy of this PowerPoint after we sign off today. And that way you can link directly to these forms and create your own form. Yeah, any questions about that? You'll have to unmute yourselves if you have one. You can ask a question about it when we start the Q&A.
Yeah.
Yeah, and put them in the chat box. So,
Yeah.
So Ken, I've scrolled up to the top of the chat box section, and you can.
Yep, I'm there.
Happy to read those for you, or you can go through them.
Yeah, the first one I see is from Teresa. It's about, does a living will get filed through the court system? Is that where you are, Marisette?
Yes.
Okay. So does a living will get filed through the court system? No, it does not. A lot of people confuse this with the durable powers of attorney. A normal, ordinary, durable POA, which historically deals with financial, safe deposit boxes, rent, whatever, those do have to be filed with the Register of Deeds in your county before they are effective. That is not true for a living will. It is not true for a healthcare power of attorney, thankfully. All right. Kathy asked, will the lack of 2 witnesses be legal in other states? That is a great question, to which I do not have a great answer. The reason is this stuff is so new that we just don't know. What I can tell you is traditionally and for 200 years, maybe less in this country, a legal document that is legal in the state it was created in will be honored in other states. And that's what we call the full faith and credit legal doctrine recognized by most states. So my guess is they will be, but that is a bit of a gray area. Okay. Okay. Someone's asking about our wishes on our thoughts on the 5 wishes document and how does the practical form compare to the NC most form? Boy, that's a loaded question. My 2 cents on 5 wishes is it is a great document. It was one of the early alternatives we had to statutory forms. I've always seen it more as a expression of wishes. I know, maybe it's not quite as mature, if you will, as the practical form. Some people love it. I personally like the practical form because I know for a fact all the hospital systems accept it, and I'm not putting a patient in risk of having their wishes not honored if they don't. I love the second question. How does the practical form compare to the NC most? Beautiful question. I'm sending you $5, Megan Cole, because it makes my earlier point, right? The practical form is an advance directive. NC most is the NC medical order for scope of treatment. It's an example of the type of medical order we always must have to effectuate an advance directive. So they go hand in glove. The reason people get confused about them is the most and the portable DNR form are the 2 standing, transportable, done in advance medical orders we have that tell a doctor, this is what I do want or what I don't want when I can no longer tell you myself. So there's a bleed over between this medical order and a healthcare POA or a living will. So they go hand in glove. The tip is always make sure the 2 are consistent if you have both. And remember that an NC most that is currently valid will trump a patient's living will that has different instructions in it so long as that most order is in effect. So we tell people if you have a living will and you later create a most, you're either going to make sure they're consistent or you're telling me I've changed my mind from what I said in my living will for now, And unless and until I revoke my most, it will trump my living will. So very important to make sure they're either consistent, and if they're not, they are consciously inconsistent. I hope that answers your question.
So Ken,
Yes.
this is Marcette, and I just want to add, a lot of times for hospice and palliative care team members, you know, there'll be a most in the home, and those are really helpful for EMS personnel because they can
Absolutely.
act on those medical orders. Whereas a family might waive in front of the EMS worker, well, she's got a living will. They can't act on that because it's not a medical
Right.
order. So
Beautiful point. And that's why a lot of our elderly patients who have maybe not had a lot of thoughtful planning will end up with only the most form, and that's fine. So, you know, they do go hand in glove often. Okay, I'm still scrolling here, Maricette. I've got Kathy Turner. I have a seal, meaning notary, not a stamp. How does that work with faxing? Do I need to get a stamp? You have just immediately exceeded my pay grade. I don't know the answer to that, but I tell you, it's a great question, and maybe one of us can track it down through the notaries in our life, because I don't know. Okay. How can we get a copy of the PowerPoint? Marcia has already addressed that one, so I will leave that to people smarter than me. Wendy asked, how is the location of the patient verified? Because remember, I said earlier that both of these remotely done documents have to state that Ken, the patient, was in Nash County, and I, the witness, or I, the notary, was in Buncombe, or whatever. There is no requirement in the law that the patient somehow prove to the witness or the notary where they are, but you are certifying to this witness and you are certifying to the notary, this is where I'm at. And so, you know, the problem would only come up if you really weren't there and you were in Texas, pretending you were in Nash County, and then you'd have a problem with the document potentially not being valid. But there is not any mechanical precondition of demonstrating where I'm sitting on day X before you can create one of these documents. Okay. Kathy asked, can you still use the new old form with the August date through that date until it passes that date? Can you still use the new old form, the August date? I think I understand the question. You're talking now about the fact that we've had these dates extended. And I guess what you're asking me is, if I help somebody create a form, which at that time said, we are acting under legislative flexibilities that exist until August the 1st, is that form still good? And the answer to that is yes. Because the earlier iteration of Senate Bill 704 with the original August date clearly said, whenever this authorization runs out, these documents remain valid and do not need to be recreated. So if you've done one in July and the law gets moved for the witness piece to March next year, you don't have to go recreate it. We will have a legislative history showing us at what point this thing was valid through August and when it got extended to March of next year, and you'll be good. I think that's what you're asking me. The second part of Kathy's question we've already answered about living wills and most. Tracy asked, can a nurse help a patient fill out a most form to then be reviewed and signed with their physician? Absolutely. Any appropriate healthcare professional is authorized to assist a patient or a surrogate with creating a most form, you know, subject to whatever authority they've been given. And in fact, we want that to happen, so people are not filling these things out. One of the things we saw in the early days were people without guidance trying to, you know, give direction, and they would say, I do want artificial hydration. I don't want artificial hydration. And when you do that, of course, you've got an invalid document because you're giving conflicting information. So, Maricette, those are the questions I see. Do you have others?
Yeah, so Ken, I do want to go back to the question that says, will a most still trump if the living will is made after the most? So I think you addressed the fact that if the most was made after the living will, it was the most valid. But
Okay.
what if the living will is done after the most, and which of the two trumps?
Great question. Thank you for catching that. I was glossing over that. I've actually never been asked that question, but I still think I know the answer. So when we teach living wills, for example, we always say if you have two with different dates, the most recent one trumps and revokes the prior one. Now that's
Right.
two competing documents of the same type, right?
That's right.
We also know that in the event of inconsistency between a living will and a healthcare POA, regardless of date, the living will trumps. It makes sense. That's the patient telling me exactly what I want versus a third party trying to predict what they thought I would want. So those are two rules. When it comes to most, the document and the law says, while a most is in effect, to the extent it is inconsistent with a living will, the most form trumps. And that superior authority is not linked to when the two were executed. So, all the more reason, if we're working with a patient who has or is creating a living will and has or is creating a most, you know what I'm going to say, right? Make sure the two are consistent or that they are intentionally inconsistent. And why would you ever do the latter? Because I've already got my living will. I like it. I don't want to go through that process again. It's uncomfortable. But I've got a short-term change in condition, and I want a different decision while I'm undergoing chemo, for example, or whatever. So I'll create the most, leave it there, knowing it's different than my living will, and at some point I'm going to end that most. And my living will, original directions will be resurrected. Make sense? Okay. I see two new messages. There's our thank yous. Okay, good. Do we have other questions?
So,
Marsha? Sorry.
Yes,
right,
if
Ken,
someone,
before
if someone
I
else
have
has,
one more thing. I have one more thing, Ken, that wasn't brought up, but I'll just ask this question because we haven't mentioned, where do people store their forms? Because that is something that people probably need to be reminded about in terms of access to store documents.
All right. So I'm going to give the big 10,000-foot answer, and then I'm going to ask Marsha if she will step in, because that's a perfect segue to give a little plug to one of our very favorite platforms and groups. So
right.
the 10,000-foot answer is put them in a place where they can be found. Make sure the people who need to find them know where they are. Your agent, your husband, your loved one, whatever. Copies to your healthcare provider, especially if you've got a standing primary care physician. The Secretary of State has a registry that where you can file them. There is a small fee there, and so you have to keep them updated. But those are the things we normally tell people to do. They're no good if they can't be found. Don't create 10,000 copies and pass them around to all your bridge club, and then change them, and don't take them back from the bridge club. So just some common sense. But Marsha, maybe you can talk about Mind My Health.
Yeah, thanks, Ken. I echo everything Ken just said. And Shannon, could you just back up the screen? I think it's to slide. Yeah, there we go. Ken mentioned that the Secretary of State has a registry. You do have to, it's not electronic, so you have to mail your forms in and pay $10 to get them there. And then just be sure that you give somebody else access to those through your code there. It's not a real user-friendly process, which is why when Mind My Health was created under the Carolinas Center for Hospice and End-of-Life Care, we created a platform through a Duke Endowment grant that allows people to, free of charge, free of cost, create a profile on the Mind My Health platform and upload their documents, create their documents there if they need to, upload them, and then share them with 3 people by email. And it is a great, next step in that question, what do I do with my documents? Because they're no good if they're in a safe deposit box. They're no good if they're in a file drawer somewhere that nobody can find. They need to be accessible at the point of care. And my husband has he's one of my care contacts. And so if I'm in the hospital, which I did for my mother this spring, the doctor said, do you have a living will? And I said, yes, she does. And I can show it to you right here on my phone. So it's a really, we hope one day to connect all these to the healthcare systems through the HIE connectivity availability, but that hasn't been done yet. We're working on that now. So, and if you would like to stay up to date, more up to date on all of this stuff, we're going to keep in touch with you by email because we have your registration emails in our possession right now. So we're going to keep you up to date on all the progress being made on the amendments and on the Mind My Health platform and the Secretary of State's platform, the registry, if they make some changes. If you do not want to hear from us after you get an initial email from us, then just write us and say, please take me off your list. Otherwise, we will keep you on there and we will keep you updated. Also, just to reiterate, we will send out the recording and the PowerPoint slides to every person who registered, who's on this webinar. So you will be getting copies of those. And if you have a question that you haven't, you can write it now in the chat room, or you can just unmute yourself and ask it.
This is Linwood. Can you hear me?
Yes.
The thing about having a video or having people that might not be in the same room or same area using the video, I thought I heard if you have 2 people who are witnesses and they're in separate offices, they can sign one document a piece and then they swap. How does that work when you have video? Do the witnesses have to be in the same area, or say if you have one person who lives in Salisbury, another person lives in Lexington, and you're doing the healthcare power of attorney with a person who's in Kannapolis?
Yep. Great question, Linwood. Thank you. This is Ken. You can have all of those people, as long as they're in the state, same North Carolina, they can be in different places. Now, the trick is, of course, you got to make sure your audio video techno will let, you connect in Salisbury and me in Rocky Mount and somebody else in Charlotte. But assuming all that can be done, they can be in 3 separate places, and you could even have your notary theoretically linked to that same interaction, and then the witnesses each sign the page where their name would be, I'm a witness number 1. Those all get scanned or faxed to the maker, who puts it together, each page, and you then have a complete document, and theoretically you could have your notary do the same thing and you're done. So it could all be done in 4 or 5 different locations, as long as they're all in North Carolina.
So each document could be separate, but then when you put all 4 of the pages together, then it becomes a single document.
That's correct. And so, because the law contemplated the mechanical struggle here, and expressly says these documents may be created in counterpart. Lawyers hardly ever anymore all sign the same document. We got 25 law firms signing a signature page. We put it together and we send it around, and everybody's got a copy. So absolutely correct.
Okay, and then the last thing, where do we put that statement that says this is being done because of Senate Law XYZ?
Yep, you can put it anywhere you'd like to do. If you open up some of those links that we sent you, that Marcia provided to us, thankfully, you'll see people have it at the top of the document. They have it under the title of the document. They have it at the bottom. So any place that you'd like to put it, if it were me, it's not required. I'd put it in bold type, just so nobody misses it, because the law says in a plain and conspicuous statement. Any
Okay.
place you want to put it, okay?
All right. Thank you so much.
Yes, sir.
So Ken, there are a couple other questions in the chat box before we wrap up. Is there somewhere that we can access free copies of the North Carolina Practical Forum, Megan has asked. And then Kathy has asked, where is the video stored?
Okay, so I'll answer the easy one first. I'll check this one. You can literally go to your favorite search engine and put in a practical forum for North Carolinians, and many links to this pop up. You can also get it on the Medical Society website. If you just put in NC Medical Society and then hit their tab for end-of-life resources, you can get it at a website called www.gotplans, GOTPLANS 123.org. I would cheat and just Google it. It'll come right up. All right. I'm not sure what you mean by where were the video stored. Are you talking about maybe the piece the notary has to record?
Yes.
Yeah, that's a good question. The notary is required, doing these remote notarizations, to keep a journal or a log of each one that they do. And there's some prescribed information in the law about it, plus whatever else they want to do. But I think these things are just recorded on whatever device you're recording them on. Most of us these days, it's an iPhone or a tablet. But the law does not say more about that. It's just they need to be recorded. So I would probably get my young nephew to take it off my tablet or phone and put it somewhere on the cloud. But it's entirely up to you as long as you can re-access it later. Okay.
Anybody else got a last minute question? I'm at 11:01.
Yeah.
And we can stay on for another minute or two and take any more questions, or you can send your questions to me directly at Marcia. I'll put it in the chat room, but Marcia at ncsicoalition.org. And you can also, I will also get the answer to Kathy Turner's question about seal instead of stamp. There may be some information on the Secretary of State's website about that. And if not, we have notaries in the coalition who have gotten more specific information that I can get from them and share with you. So we will be back in touch on that. Anything else for the good of the cause here?
Well, thank you all very much for listening to me ramble on for 45 minutes. I appreciate it.
Nice rambling, Ken.
Ken, can you confirm your email address? Shannon said that it looked a little different, so could you confirm that for those on the line, or put it in the chat box?
Yeah, so it's correct. It's K Burgess. You can use this. It's K Burgess at pointersprul.com, which is POINERSPRUILL.com. But Mary said that shortened version on the screen, which is pointers.com, also works.
Okay. That sounds good. We wanted to be sure we had it correct. Thank you.
Thank you.
Okay. Great to have you all with us, and let us know. Stay in touch. We'll stay in touch with you, and have a great week.
Thanks.
Okay.
Bye-bye.
Thank you, Ken. Bye.
All right.
Thank you,
Thanks,
Marcia
everyone.
and Shannon.
Oh, you're
as well.
welcome. Glad
Okay.
to be involved.
Bye.
You guys have a great day. Bye-bye.